Picture this scenario. Your wife is 8 months pregnant. She is having contractions. You rush her to the emergency room. You are sitting in that waiting room, terrified, holding her hand. And two people in plain clothes walk in. They are not doctors. They are not nurses. They are ICE agents. And they are looking around the room. If you are like most people who reach out to U.S. green card signal, you probably believe one of two things right now. Either you think hospitals are protected locations and ICE cannot approach you there, or you think hospitals have become dangerous and you are never setting foot in one again. Both of those positions are wrong, and either one could cost you everything. I'm Edward, and this is U.S. Green Card Signal, the channel where we do not deal in rumors, social media panic, or unverified advice. We deal in law, we deal in documents, and we deal in the truth. Today, I am going to show you the exact federal directive that changed the rules around hospitals. I am going to walk you through 5 specific traps that are getting people detained inside healthcare facilities right now in 2026. And then I am going to give you the legal shield, the precise language you need to use if ICE ever approaches you or a family member in a medical setting. Do not skip ahead. Trap number 4 is the one that catches even green card holders completely off guard. The legal reality as of 2026, what the official record actually shows. Before anyone suggests this is an exaggeration, let's look at the documented record. On January 20th, 2025, the Department of Homeland Security issued a directive titled Enforcement Actions in or Near Protected Areas. What that directive did was formally rescind, cancel entirely, the policy from October 2021 that had designated hospitals, schools, and churches as protected locations where immigration enforcement should be avoided. Then on January 31st, 2025, ICE followed up with its own internal memo titled Common Sense Enforcement Actions in or Near Protected Areas, which gave local ICE supervisors discretionary authority to make case-by-case decisions about whether to conduct enforcement inside hospitals. This information is documented on ice.gov, the official website of U.S. Immigration and Customs Enforcement, updated as of February 20th, 2026. The bottom line, stated plainly, there is no federal policy currently in effect that categorically prevents ICE from entering a hospital and making an arrest. That is not an opinion. That is the documented current policy. A court injunction issued in March 2025 did restore some protections, but only for approximately 1,400 specific places of worship in 36 states. That injunction does not cover hospitals. Not one hospital in the United States is covered by that court order as of today. Does this mean you have no rights? Absolutely not. The Constitution was not rescinded, and that is exactly what we are going to break down now. Trap 1. Believing the old policy still protects you. This is the first and most foundational mistake, and it is extremely common. From 2011 through January 20th, 2025, the Department of Homeland Security maintained a standing policy designating hospitals, schools, and churches as sensitive locations where immigration enforcement should generally be avoided. The Biden administration expanded that protection in 2021. That policy no longer exists. It was formally rescinded on the first day of the current administration. If you are walking into a hospital in 2026 believing you are covered by some form of legal protection simply because of the location, you are operating on outdated information. That false sense of security is the first trap because it shapes every decision that follows. Trap 2. Speaking when you should be silent. This is the trap that causes some of the most preventable harm because it is genuinely simple to avoid, yet it happens constantly. A survey published in January 2026 found that approximately 48% of likely undocumented adults had avoided seeking medical care since January 2025 due to immigration concerns. But here is the painful reality. Some of the people who do go to the hospital end up making the situation worse by talking. ICE agents can enter the public areas of a hospital, the lobby, the waiting room, the parking lot, without any warrant. And while they are there, they are permitted to ask questions, but you are not required to answer them. The Fifth Amendment of the United States Constitution guarantees every person on U.S. soil, citizen, visa holder, green card holder, undocumented individual, the right to remain silent. That protection does not disappear because of your location or your immigration status. If an ICE agent approaches you in a hospital setting, the only words that need to come out of your mouth are these: I am exercising my right to remain silent. I do not consent to a search. I want to speak with a lawyer. Here is why this matters so urgently. If you respond to questions, you may confirm your name, your country of origin, how long you have been in the United States, or other details about your situation. Those answers can give ICE the probable cause they need to detain you and initiate removal proceedings. Your own words become the primary evidence against you. Silence is not suspicious behavior. Silence is a constitutional right. Use it. Trap 3. Running from ICE inside a hospital. This happens more often than people realize, and it is critically important to understand why you must not do it. When someone sees ICE agents in a hallway or waiting area, the instinct is panic, and panic can produce a very dangerous response: running. Do not run. According to legal guidance from the National Immigration Law Center, running from ICE agents can independently establish probable cause for an arrest, even if the agents had no legitimate basis to stop you before that moment. By running, you may have just provided the legal justification they needed. Running can also lead to additional criminal charges: obstruction of justice, resisting arrest, and once criminal charges enter your immigration case, the complexity and consequences increase dramatically. Stay where you are, stay calm, state the sentence above, wait for legal counsel before saying or doing anything else. Trap 4. Not understanding the difference between two types of documents. This is the trap that catches even lawful permanent residents and visa holders, people who believe they understand the system. And it is perhaps the most important distinction in this entire video. ICE agents carry two fundamentally different types of documents. Most people cannot distinguish between them. But the legal difference between these two pieces of paper is enormous. A judicial warrant is signed by a federal judge. It will display the words United States District Court at the top of the document. A judicial warrant does authorize ICE to enter private areas of a hospital, patient rooms, examination rooms, surgical areas, staff offices. An administrative warrant, Form I-200 or Form I-205, is signed by an ICE officer, not a judge. Constitutional law organizations including the ACLU and the Brennan Center for Justice maintain that an administrative warrant does not satisfy the requirements of the Fourth Amendment for entry into private spaces. I want to be transparent with you about where this stands legally. This question is currently being contested in federal courts. The government's position is that administrative warrants may be sufficient in certain contexts. However, the current legal consensus from organizations including the ACLU, the National Immigration Law Center, and the Immigrant Legal Resource Center is that an ICE administrative warrant alone does not authorize entry into a private hospital area without the consent of an authorized person. If you work in a hospital, you have the right to ask, is this a judicial warrant signed by a federal judge? If it is not, you are not legally obligated to open that door or grant access to private patient areas. Know the difference between these two documents. That knowledge is protection. Trap 5. Signing documents you do not understand. In January 2026, a 31-year-old man in St. Paul, Minnesota was arrested during an enforcement operation and was transported to a hospital with serious injuries, including skull fractures and life-threatening brain hemorrhages. ICE agents remained at his bedside for days. According to reports, there were attempts to have him sign documents while he was severely disoriented from traumatic brain injury, disoriented to the point where he was not aware of the date or year. Hospital staff, the hospital's legal team, and eventually a federal judge intervened and ordered his release from ICE custody. But consider what would have happened if he had signed a voluntary departure form while in that condition. Consider what it would have meant if he had signed away his right to a hearing before an immigration judge. That is precisely what those documents do. And the legal consequences are severe. Under INA Section 212A9, signing certain forms can trigger a mandatory 3-year bar, a 10-year bar, or in some circumstances, a permanent bar from re-entering the United States. Never sign any document, not in a hospital room, not in a detention facility, not anywhere, until you have spoken with a licensed immigration attorney who can explain exactly what you are signing and what the consequences are. Your legal shield for protections that remain fully active in 2026. Now let's move from the traps to the protections, because you have rights and they have not been eliminated. Shield 1, the Fourth Amendment. ICE agents can enter public areas of a hospital freely. To enter private areas, patient rooms, examination rooms, surgical areas, they need either a judicial warrant signed by a federal judge or the voluntary consent of an authorized hospital representative. An administrative warrant, according to the ACLU and NILC, does not meet this standard. This protection is grounded in the Constitution itself. Shield 2, the Fifth Amendment. Every person on U.S. soil has the absolute right to remain silent. You are not required to answer questions about your immigration status, your name, your country of birth, or any other personal information. This right applies regardless of your documentation status. Exercise it clearly and calmly. Shield 3. HIPAA. The Health Insurance Portability and Accountability Act protects your medical information. Hospitals have no legal obligation to ask about your immigration status or to report it to immigration authorities. Your medical records are protected under federal law. In California, state law enacted in September 2025 adds further restrictions on health facilities sharing patient information with immigration enforcement agencies. Shield 4, EMTALA. The Emergency Medical Treatment and Labor Act, federal law enacted in 1986, requires that any hospital receiving federal funding must screen and stabilize any patient who arrives with a medical emergency. They cannot ask for your immigration documents first. They cannot turn you away based on your status. This law is fully active in 2026, and it protects you and your family. Your action plan. 4 steps to take now. Here is what Edward and the U.S. Green Card Signal team recommend you do based on everything we have covered today. Step 1. Memorize this sentence and teach it to your family. I am exercising my right to remain silent. I do not consent to a search. I want to speak with a lawyer. Practice it in English. Teach it to every adult in your household. Make sure everyone knows it before they ever need it. Step 2. Carry a Know Your Rights card. The ACLU and the Immigrant Legal Resource Center both provide printable Know Your Rights cards that you can download and carry for free. Links are available in the description below this video. If an agent approaches you, hand them the card. Say nothing further. Step 3. If you work in a healthcare setting, establish a clear protocol. Designate one specific authorized individual to handle ICE interactions at your facility. Train staff to respond with, "I am not authorized to consent to your entry. Please present a valid judicial warrant signed by a federal judge." Document every interaction in writing. Step 4. Have a legal emergency plan in place before you need it. Know the phone number of a qualified immigration attorney before any situation arises. Have a plan in place for your children. Consider having power of attorney documents prepared. This is not an expression of fear. It is an expression of preparation. There is a meaningful difference between those two things. Do not stop seeking medical care. Before we close, I want to say this clearly and with full sincerity. Do not stop going to the hospital. EMTALA is federal law. You have the legal right to emergency medical care regardless of your immigration status. Children who need vaccinations should receive them. Pregnant women who need prenatal care should receive it. People with medical emergencies should seek treatment. A survey by Physicians for Human Rights found that 84% of healthcare workers across 30 states have observed a decline in patient visits since the executive orders took effect. Children are arriving at emergency rooms alone because their parents are afraid to walk through the door. That fear is understandable, but avoiding necessary medical care can cost you your health, and it can cost your children their lives. Go to the hospital. Know your rights. Exercise them calmly and clearly. A note on how quickly. This area of law is changing. Everything covered in this video is accurate as of March 2026. But this area of law is evolving rapidly, sometimes week to week. New court rulings, new state-level legislation, new ICE policy memos. What is accurate today may shift in the coming weeks. That is exactly why U.S. Green Card Signal exists. When a rule changes, when a court issues a new injunction, when a state passes new hospital protection legislation, when ICE releases a new enforcement memo, our goal at U.S. Green Card Signal is to get you that information clearly and quickly so you are never making decisions based on outdated guidance. Follow U.S. Green Card Signal and keep notifications enabled so you are never behind on a development that could directly affect your safety and your family's security. Before you close this video, think about one person right now, a family member, a friend, someone in your community who still believes hospitals are categorically protected locations. Someone who is avoiding the emergency room because of something they saw online. Someone who does not know the difference between a judicial warrant and an administrative warrant. This video could be the information that keeps them from making a mistake they cannot undo. Share it with them, not for U.S. Green Card Signal, for them. If this gave you genuinely useful, documented legal knowledge today, please take a moment to engage with it. It helps U.S. Green Card Signal reach the people who need this information most. I'm Edward from U.S. Green Card Signal. Stay informed, stay prepared, and we will see you in the next one. This video is intended for general informational and educational purposes only. It does not constitute legal advice and does not create an attorney-client relationship. Laws, policies, and court rulings in this area are changing rapidly. Please consult a qualified, licensed immigration attorney for guidance specific to your individual situation. Always verify current information through official sources.